For 2 decades, Congress largely sat on its hands as one president after another began asserting a right to set aside the rules at his own discretion, along with related power grabs such as keeping ever more information secret from oversight committees and the courts through such inventions as the term executive privilege, which did not predate the 1950s, and the state secret privilege, first recognized in the 1950s. Presidential power thus steadily escalated for 2 decades, peaking during the Nixon administration. But Richard Nixon pushed the logic of presidential power to the breaking point, and his imperial presidency came crashing down amid the abuses that we know of as the Watergate scandal. In the wake of the twin disasters of Watergate and Vietnam, Congress finally reawakened. It began conducting meaningful oversight again for the first time in decades, and it began passing a series of laws reimposing controls on executive power in order to prevent future abuses. And understanding that moment in the mid-1970s is crucial for understanding what has been happening today. Because day upon day in Gerald Ford's White House, Dick Cheney was the White House Chief of Staff, the youngest White House Chief of Staff in U.S. history. And he was confronting a Congress that was determined to reimpose controls on White House power. And as his memos show, his documents in the National Archives files, from inside the White House, this period did not look like a necessary constitutional correction. It was an outrage. They felt that they were being punished for Richard Nixon's personal failings, that they were different, that they could be trusted with these powers, and more importantly, in fact, they felt that these reforms would weaken the commander-in-chief and that that meant weakening America. And so Cheney and those who felt like him abandoned the traditional conservative suspicion of concentrated government power and spent the next 30 years seeking to roll back the changes of the 1970s, to refight those battles and win them this time, and to restore presidential power to the inflated level that it had briefly, aberrationally reached under Richard Nixon before his fall. You can see Cheney's agenda in the decade he spent as a member of the House of Representatives, when he was continuously arguing with his colleagues that they ought to be giving the president more flexibility, not less, in foreign affairs and national security matters, not just during the Iran-Contra scandal, but throughout that period. You could see it in his tenure as the Secretary of Defense to the first President Bush, when he unsuccessfully argued that George H.W. Bush ought to launch the Gulf War without going to Congress for authorization, as a demonstration that Truman was right, that it was, is, and always would be legal for a president to do that. During my research, I found all kinds of essays and speeches in which Cheney, in his much more candid days prior to his vice presidency, explained his view. In 1989, for example, Cheney wrote an essay for a talk he was going to give at the American Enterprise Institute, a conservative think tank, about what he termed congressional overreach in foreign policy. As it turned out, he never delivered that talk because he was nominated to be Secretary of Defense, and he wanted to avoid controversy before he was confirmed. But during my research for my book, I obtained a copy of the undelivered speech. And in it, Cheney explains that he wanted to get beyond the legal arguments over the possible meanings of what he somewhat disparagingly calls the parchment document, that is, the Constitution, and explain why, for pragmatic and real-world reasons, he endorses an interpretation that gives stronger powers to the president and a lesser role for Congress. It turns out that Cheney takes the opposite view of the founders, who you will recall thought that it was too risky to let just one person, one flawed human being, control major national security decisions. Cheney said that it was too risky to have more than one person control such decisions, because, he argued, any system in which the body of elected representatives gets to influence these big decisions on national security would increase the likelihood of leaks and diminish the likelihood of a proposed covert strike or military attack from going forward. And thus, Cheney wrote back in 1989, quote, "The real-world effect often turns out not to be a transfer of power from the president to Congress, but a denial of power to the government as a whole," close quote. In other words, he wants the United States, given its role in the world, to be more aggressive about launching attacks and taking other actions in the intelligence world and national security matters. And he knows that the country will be more aggressive if the commander-in-chief gets to make such calls completely at his own discretion, if there are no rules to which he is subject, and if he has exclusive control over the zone of the nation's intelligence activities and military operations. And quite obviously, Cheney is right about that. We would be more aggressive. There were others who agreed with Cheney that presidential power ought to be put back to the level it briefly achieved before Nixon's fall. But their goal faced a legal obstacle. Because even if you buy into the idea that the Constitution gives the president vast, unwritten, or inherent power, an inherent executive power is not the same thing as an exclusive executive power. It's one thing to say that if necessity arises, the president can direct the government to do something that he was not specifically authorized to do by the Constitution or a federal statute, because he has inherent power as commander-in-chief to do that. But it's a very different thing to say that Congress cannot choose, if it wants, to step in and pass a law regulating how the president goes about doing that thing from now on. For example, before 1978, there was no law in the books about wiretapping to prevent spies and terrorists from striking on U.S. soil. Maybe the president has inherent power to wiretap in order to catch such folks. But even if he has that inherent power, does that mean that he has exclusive power, that if Congress steps in 1978 and says, from now on, if you want to do that, here's how you have to do it, you have to get a warrant from a judge, they can't do that. They share no power. Inherent power versus exclusive power. But during the 1980s, presidentialists on the Reagan legal team came up with something we heard about this morning called the Unitary Executive Theory. This is a revisionist understanding of the Constitution whereby Congress may not pass laws that fracture the president's control of anything deemed to be an executive power. Now, back in the 1980s, advocates of the theory on the Reagan legal team had been thinking about relatively tame domestic issues, such as control of decisions made by the supposedly independent agencies like the Federal Reserve, not national security matters. Since Congress had created an entity that had the power to raise and lower interest rates, the Federal Reserve, for example, maybe that's an executive power. And if it's an executive power, maybe the president should get to exercise it. But after 9/11, the Bush administration's legal team revived the unitary executive theory and dramatically expanded its sweep to encompass matters of inherent power and national security. In their hands, the unitary executive theory transformed the commander-in-chief's inherent responsibility to protect national security into an exclusive executive power that Congress cannot regulate. If this vision were accepted as true, then the unchecked powers sought by Cheney and his allies all those years already existed, regardless of what Congress chose to say in the statutes it passed and the treaties it ratified. These powers were just slumbering in a wait of a president willing to start using them and thereby to demonstrate that they existed.